Hello and welcome to my channel. Go ahead, hit the like, hit the share. This video is going to be a subscriber's request. I was asked to post the audio for R. Kelly's appeal he just had yesterday. And you know I'm going to post it in a way that only I will do, because I want to put some things on your mind. Now, I'm not going to comment about my thoughts in regards to some of the things that were said during the appeals hearing, but I just want to reinforce what we're fighting for. Because like I said last year, it's obvious this man is honoring his code of silence, his brotherhood, whatever's going on here. But at the end of the day, we all see lies and deception going on. And the target that they've put on R. Kelly is clear. But if they want to keep running these narratives that they're running, it would be quite obvious that it's a whole lot of missing people from this case. And we're going to start focusing on them as well, because the people that have not done their research are walking around talking about this enterprise, but they're not recognizing that they've already mentioned in the first few indictments that they're building this enterprise off of managers, assistants, and all these people that were working for R. Kelly. Never mind the fact that we didn't see them appear in the earlier indictments. Either one or two things should have ran through your mind. Either A, these people that they have in mind are going to be cooperating. Some may be informants. As we know, the FBI loves to use those people that love to break the law and then cut a deal. Or something just ain't right. Now, it's kind of strange that these people want to keep speaking on this history of abuse, this history of obstruction of justice and all this bullshit. But at the end of the day, there is no history of abuse. There is a history of allegations, and there is a difference. So when I started to see these people that are saying they are affiliated with R. Kelly pop out the woodworks, conducting interviews, I kind of felt like that would be a bad idea. But guess what I did? I minded my motherfucking business, and I just watched. Because anybody with common sense know that they got their eyes on the people that are supposed to be close to R. Kelly, considering this is a RICO case. So some things that were said, some things that were put on public display, some of that shit should have been done offline. Nonetheless, as we saw it all play out, we began to see how this story connects and how a lot of these people were around during his first trial. And some of those same people have joined forces with those people using this man's history of allegations against him to take this man out. Now, it's clear that so many of these people know each other. So many of these people were around during some of these alleged actions. So we're just going to have to wait and see just who is loyal and who is not. But at the end of the day, it should make you think. Again, if they're saying this man's sole purpose in performing and making music is to solicit girls, it's going to be okay for you to cut deals with people who want to tell you whatever they need to tell you to get themselves out of trouble. For all we know, these people could have been engaging with these girls, considering we know that the non-disclosure that they like to talk about with R. Kelly, that not only covers him, but it covers his entourage. So if his entourage is out here fucking up, guess who is responsible by The law, anyways. The boss, right? Yeah. When they tell you about this history of abuse, isn't it ironic how they always skip by the fact that R. Kelly had people who have been employed by the police, who have a police background, as his bodyguards? Many fans have stated that his concerts were for people 18 and up. So a lot of the things that they're saying just makes no sense. A lot of people even jump down his brother's throat for something that he said. Well, let me point it to you like this. Did you know that with a house such as R. Kelly's, of course he has security footage? So for someone to imply that they were secretly recorded without their knowledge, it's questionable. Even more questionable when it comes to these alleged tapes they have found. Considering that the man did have security footage, why didn't they try to get that actual footage, considering we don't know the chain of custody with this tape? The thing that bothers me the most is the reaction that people came out with hearing that R. Kelly was attacked. And my thing is, if he's this well-known predator, as they have said, why is it he has been in general population all this time and hasn't been attacked? They must think we crazy out here, because they flip these scenarios about these underage girls like they don't recognize that people from the hood know that they will have no problems using an underage girl to carry out whatever mission they want to carry out. They act like it's uncommon for an underage girl to make a false allegation against someone and cost them their life. Look at Marilyn Santana. Look at all the people who have lost their lives as a result of false allegations. So let's point this last thing out before I go on to the audio clip, because I'm sick and tired of people talking about this history of allegations. Well, guess what? It's not a goddamn thing we could do when all these people want to sit here and tell us what they knew but didn't act on. So if all these people knew, they are the enablers, not us. We don't have direct access to these people. So how the fuck can they imply that R. Kelly's supporters are enablers when they are the ones who have been working with this man all these years? They have been around this man all these years. And a lot of these people have greatly prospered through their relationship with this man, even if it wasn't a real relationship, period. Now, when they speak on this history of allegations, they need to recognize that this history is being driven by the same individuals, planting the same stories over and over and over. And what's strange is these girls are not what's important. And the reverse psychology they put in our mind is nobody cares about the black girls, when they know very damn well this whole case against R. Kelly has absolutely nothing to do with these accusers being used to tarnish his brand. Only in America can you watch a girl proclaim she's 18 years old with an ID, turn back around and say that she was assaulted by the person she was stalking. How does that make sense? People keep saying, oh, well, she admitted she lied about her age. Well, she didn't admit that she also had a fake ID, that she passed that off to reporters at his first trial, and that if she fooled these officials, why the fuck y'all think R. Kelly's supposed to be this superhero to just know everything? Makes no sense. You got reporters out here speaking on the extortion and then being used in this docuseries to slander R. Kelly, even though they know very well this was an extortion plot from the beginning. You got people who were comfortable living the lifestyle who conveniently now want to be victims. And if you go down this history that they like to keep speaking on, you will notice something very clear. This fake document that they use, labeled a certificate of marriage, is what they have been using to extort this man this whole time. Just go and look through the history, since they want to keep bringing it up. And ask yourself, why is it every time there's financial issues, the IRS is popping up, other lawsuits are popping up, contrary to the bullshit they want to tell the public? According to R. Kelly himself, he only settled 3 lawsuits. So where the fuck are the rest? They may be tied up in shady businesses. So it's easy for us to speak on things we don't know. But just do your research on this history. And I guarantee you'll see just what I see. This is a pure money grab. And at the end of the day, every citizen in America has rights. They have a right to a fair trial. And the fact that they would use a movie to engage in an investigation when they have already spent years investigating with no result tells you a lot. They use propaganda to brainwash you into turning a blind eye to this injustice. Oh, but we won't be silent. Believe that. Here's the clip. Leave your comments below and tell me what you think of this so-called history of allegations and how you felt the attorneys represented in this appeal.
I thought this was America, people.
Take the matter under advisement. The next case on the calendar is United States v. Kelly.
Good morning, Your Honor. May it please the court. Thomas Farinelli for Mr. Kelly, the defendant appellant on this appeal and the case below.
Yes, Mr. Kelly. I just wanted to just say we'll also give you 2 minutes before we jump in.
All right, thank you. I appreciate the court's. Mr. Kelly has moved for pretrial release in light of the recent precedent resulting from the coronavirus pandemic, which unequivocally supports his temporary release in order to prepare for trial. The appeal is based on clear error because, among other things, the district court, after determining that a change in circumstances did not compel reconsideration of Mr. Kelly's bond conditions, failed to consider that Mr. Kelly must prepare for his imminent trial, which is a compelling reason under 18 U.S.C. Section 3142. It has been almost 6 months since Mr. Kelly has met with his attorney. While this issue is not unique to Mr. Kelly, during this time, his circumstances are unique and exceptional because of the undisputed fact he cannot read and write. The district court did not consider this undisputed fact and did not discuss or address Mr. Kelly's ability to prepare for trial and the impact of the COVID-19 pandemic in its last denial order of May 15th. Other than writing that Mr. Kelly would have an adequate opportunity to prepare for his upcoming trial, which at this point seems difficult even if he is released, and impossible if he is not released, given the current climate. Additionally, Mr. Kelly has been the subject of an unprovoked attack while incarcerated at the NCC because of who he is, and it is clear that the Bureau of Prisons cannot adequately accommodate the need to keep him safe. And additionally, the imbalance that's created by Mr. Kelly not being able to meet with counsel and prepare for his limited ability to read and write violates his guaranteed right to a fair trial. The right to counsel and the purpose, the right to counsel and I apologize, Your Honor. The right to counsel is a guaranteed right, Your Honor. And at this point, it is being denied to Mr. Kelly.
Is there a trial date scheduled at this point?
Your Honor, there has been two trial dates, and they've been, right now at this point, the last trial date has been converted to a status conference. However, jury selection has been adjourned twice.
Excuse me, where is he incarcerated at the moment?
It's currently he's incarcerated. Thanks for the question, Your Honor. Currently he's incarcerated at MCC in Chicago because he's also facing the charges in the Northern District of Illinois and the Cook County State Court.
Is he going to be tried there first?
I believe he's going to be he is going to be tried in the Eastern District first, Your Honor.
First.
Yes.
So he's sitting in an Illinois detention center waiting for trial in the Eastern District. That's where things stand right now.
Yes.
And he's been there for about a year at this point.
Yeah.
It's over a year, Your Honor. He was arrested on July 11th of 2019.
And can you just tell us what your level of contact is with him? I mean, you described it briefly, but I'd like to hear it in more detail. How you're consulting with your client?
At this point, Your Honor, it's extremely difficult to consult with Mr. Kelly. Mr. Kelly has a number of lawyers, and they've had limited conversations. They're limited to 15-minute phone calls with him, and there's essentially, the protocol at this point is the prisons are not accepting visitors, and there's a very strict protocol with regard to prison calls, but they have to be scheduled, and Mr. Kelly is facing a number of charges that contain thousands of documents, and it's seemingly impossible to have any substantive conversation under the current restraints that are in place at this time.
Why isn't the solution here not to grant bail, but to make sure that the district court accommodates counsel's need to meet with him when he returns to the Eastern District? Perhaps schedules a conference and then makes rooms available next to the courtroom, that kind of thing, so that there can be conferences. It seems to me that this is sort of a trial management issue, in a way, to allow counsel to prepare, rather than this sort of this blunderbuss approach of just releasing him. He faces very serious charges. There's lots of reasons not to release him. And if we didn't have coronavirus, I don't think you'd be here. But why not just leave it up to the district judge in the Eastern District when the time comes to make sure that he's has adequate time to meet with counsel?
Well, Your Honor, I appreciate the court's question. The reality is there are other defendants who have already been convicted of serious felony and who have also been determined have been determined that they are a flight risk or dangerous to the public, and they have been afforded the right to be released to prepare for trial. United States versus Avenatti, the court set up a very specific set of restrictions where the defendant's ability to communicate with the public was severely limited. He can't have any outside communication. He cannot have any cell phone. He must be on monitoring. He cannot use the internet without him being in the presence of counsel. And there were accommodations made because to the United States versus Avenatti, he is facing a numerous amount of charges that entail the need and necessity to prepare for trial.
Well, the standard of review is not helpful to you, right? I mean, we reversed a district court for clear error based on a firm conclusion that they've made a mistake. And here the district court, looking at the seriousness of the charges and factors about your client, came to a determination that he would be a risk of flight and a danger to the community. And this is a presumption case, and all those are factors that make it your argument more difficult. In fact, the original detention order was not appealed. But now you're arguing, I think, those two things, and correct me if I'm misunderstanding, you're both saying that there's a compelling reason for him to be released now because of the need to prepare for trial, and that the court got it wrong on that original detention order. Do you want to address the second of those? What was wrong with the actual determination of the judge that this was an appropriate detention case?
Well, the court basis for determining risk of flight for Mr. Kelly and for the court's determination that he obstruction is based on speculation. And Mr. Kelly has had prior proceedings. He has always appeared in court. The court did not weigh the fact that Mr. Kelly has been a very cooperative defendant. As a matter of fact, when he was arrested in Chicago on the charges he was walking his dog, Mr. Kelly has never demonstrated that he intends on fleeing. And another thing is that even
apart from a flight, there's a risk. Obstruction of justice counts, and as a risk element here, and he has a history of that. Going back to the 2008 trial in Cook County, he was ultimately acquitted, and they found obstruction and intimidation of witnesses there. Why isn't that a relevant concern now?
But Your Honor, thank you for the question. It's not a relevant concern now because he hasn't been found to have obstructed. He's been accused of that in the Chicago, in the Northern District case. But at the end of the day, the evidence presented, there was no record of evidence that demonstrated that he was likely to commit obstruction on. Again, the record is based upon speculation, and the underlying the initial decision didn't consider that there are in fact conditions that can be, even if we can see the construction argument, the obstruction argument, there are underlying conditions that can be put in place by the Bureau of Prisons to monitor Mr. Kelly, to restrict his access to by way of telephone, cell phone, internet access, and use of the computer only in the presence of counsel, by which it would ameliorate that concern.
We'll hear from the government. And you've reserved 2 minutes of rebuttal, Mr. Now.
Yes, ma'am. Thank you.
May I please the court? Good morning. Maria Cruz Melendez, Assistant United States Attorney for the Eastern District of New York. I represent the United States. C.F. Kelly in this matter. The appellant, Robert Kelly, is charged in the Eastern District of New York as the leader of a racketeering enterprise engaged in racketeering activities spanning 2 decades, involving bribery, kidnapping, sexual assault, sexual exploitation of minors, coercing and transporting girls and women to engage in illegal sexual activity and forced labor, as well as with multiple Mann Act violation charges. As Chief Judge Livingston pointed out, the grand jury's finding of probable cause that Kelly committed multiple offenses involving minor victims subjects Kelly to the rebuttable presumption that no condition or combination of conditions will reasonably assure his appearance and the safety of the community. Now, the district court properly found that the defendant failed to rebut that presumption. And notwithstanding the defendant's claims, this determination is strongly supported by the record. It's not mere speculation. For example, as Judge Walker pointed out, there is a history of obstruction. A grand jury in the Northern District of Illinois found probable cause that Kelly engaged in a long-running conspiracy to obstruct justice in his 2008 trial, where he secured witnesses' silence and suborned perjury through bribes, blackmail, threats, and intimidation. In addition, based on the 2 pending federal indictments, there's also probable cause that Kelly committed at least 5 serious crimes while on bail awaiting his 2008 trial, namely kidnapping and Mann Act violations alleged as racketeering acts in the Eastern District of New York, as well as charges of obstruction and conspiracy to receive and receiving child pornography in the Northern District of Illinois. And additionally, the government made multiple proffers regarding Kelly's long history of interfering with, intimidating, and threatening potential witnesses against him, including the potential witnesses and victims related to charges in the Eastern District of New York. And as the district court found, Kelly poses a flight risk, given the serious charges he faces in multiple districts. In the Eastern District,
the argument that there is a compelling reason for release here because it's really impossible to prepare for this trial given the circumstance of his incarceration in Illinois, his detention in Illinois, and the lack of access that counsel have to him.
Your Honor, the BOP has restricted some access to counsel, but ultimately with regard to accommodations for the purposes of preparing for trial, as I believe Judge Walker pointed out, that really is a trial management issue for the district court. The BOP's limitations on attorney visitations is reasonable given the coronavirus pandemic and given the fact that Mr. Kelly still has access to his attorneys via telephone calls, which, if scheduled, can be unmonitored. And in fact, the BOP has made clear that to the extent defense counsel wishes, they can schedule in-person appearances with their clients. If defense counsel
I'm not sure I understand the dynamics of the fact that he's incarcerated in Illinois, and we're talking about a trial in the Eastern District that's scheduled to go first. And we would be issuing an order if the other side prevailed, presumably to the Bureau of Prisons that would affect his detention in Illinois. And I'm not sure why he would be in Illinois even. Go ahead. Yeah, clarify the just when the trials can take place is an important factor.
Yes, Your Honor. When the defendant was arrested initially on an arrest warrant issued in the Eastern District of New York, and then subsequently an arrest warrant issued in the Northern District of Illinois, almost simultaneously. He was arrested in Chicago, Illinois, so he was housed at the MPC Chicago. For at least one appearance, the defendant has been transferred to the MPC in New York, but in terms of consistency, it's been determined that he'd be housed at MPC Chicago. Now, when the trials have been scheduled, the Eastern District of New York trial, the most recent scheduling, was set to occur before the Northern District of Illinois trial. The original trial was scheduled in the Northern District of Illinois. They had the first date. Since that time, because of various logistical issues, there have been adjournments, and currently there is no trial date. However, it's likely that the trial date will be scheduled appropriately in the future at the next status conference. But yes, Judge.
Where will that trial be?
The trial for the Eastern District of New York will take place in Brooklyn.
Yes, but you said there's going to be one scheduled. Is the first trial going to be in the Eastern District, or is it going to be in Illinois?
It's unclear at this point because there is not a trial date scheduled in the Eastern District of New York, whether or not that will take place before the Northern District of Illinois trial. The district
so it's not clear now which trial is going to take place first.
That's correct.
He might stay in Chicago for a period and go through that entire proceeding before the trial in Brooklyn.
That's correct. Or if trial proceeds first in the Eastern District of New York, the defendant would obviously be transferred to the Eastern District of New York for the purposes of trial, preparing for trial and being present at trial.
You said that there was a possibility of in-person appearance with your client while detained in Illinois. What are the conditions on that? Is that at the detention facility? You can meet in person with your client if you arrange it?
That's correct. Defense counsel can meet in person with their client if they arrange it with the Bureau of Prisons and the local facility. It will be done on a case-by-case basis, but my understanding that the BOP is doing everything that they possibly can in order to accommodate those requests. And again, I would point out, Your Honor, that given the fact that no trial is currently scheduled, and the fact that the defendant currently has access, albeit more limited access, that there has been no violation either of his Sixth Amendment right to access to counsel or any compelling reason at this time, Your Honor, for the purposes of releasing him even temporarily, given the previous finding by the district court, he poses both a danger to the community and a risk of flight.
This is Judge Jacobs. Do I understand that he's been in prison for a year, and the only opportunity he's had to meet with counsel has been unmonitored phone calls by appointment for 15 minutes at a time?
No, Your Honor, I think it's a misstatement by defense counsel.
What if he had? What if he had? He's been in jail for a year. I mean, it's all very well to say, well, when the trial is scheduled, it'll be a trial scheduling matter to see whether he can see his lawyer. But he's been in prison for a year, and it's certainly remarkable that you know, right now and for the foreseeable future, all he'll be able to do is talk to his lawyer on the telephone for 15 minutes at a time by prearrangement.
I understand Your Honor's question. However, I would like to clarify that the pandemic has only been in place since March. Prior to that time, to the extent counsel wanted to discuss discovery and meet in person with his client, he was more than free to do so. And in fact, counsel for Kelly has done so. With regard to the question of whether or not there is a concern that there's no trial currently in place, the district court has made very clear that we're moving forward. And as the things return to normal, the district court is very much so looking to put a trial on the calendar. In fact, defense counsel has suggested November for the trial. And while the district court was not able, because of a scheduling issue, to schedule it for November, all of the parties are in discussions as to how quickly thereafter the trial would be able to happen. And I would note, to Your Honor, the fact that with respect to adjournment, the defendant has not objected to adjournment with regard to the Speedy Trial Act, and that they're in the interest of justice. In that regard, with regard to the charges, as I believe Judge Walker pointed out and Chief Judge Livingston, the charges are serious in this case. It's not unusual that there would be adjournments for the amount of time that has happened here in this case, even assuming the pandemic.
They're more serious, the charges, and you spent probably a full minute listing them, and they're quite formidable. Truly, that's an argument in favor of incarceration arrangements in which he can consult with his counsel and prepare for his defense the same way you and your team can prepare to prosecute him.
That's correct, Your Honor, and I don't think it's anyone's position that the defendant isn't entitled to prepare for trial. I think the question is whether or not in the district court's May 15th order, whether or not the court erred in finding that at that time in May, when the trial was scheduled for September, that was not a compelling basis for the purpose of releasing the defendant, even temporarily, given the risk that he posed to the community and the risk of flight that he posed.
When you say even temporarily, do you mean even to for several hours on a given day in a monitored, secured place near the courthouse or in the courthouse?
No, Your Honor. I think 3142I is often envisioned for the purpose of, as you mentioned, a few hours in courtroom or multiple days in a row in order to be able to go through documents. However, the way defense counsel requested temporary release in this case was essentially bail in the defendant's apartment under certain conditions like electronic monitoring and or curfew. And the the district court found reasonably that those types of conditions were completely and utterly, that those types of conditions would not properly secure the defendant, given his history of interfering with witnesses and victims. And that even if the defendant was wearing, for example, an electronic bracelet, that he could either secure an unauthorized phone or have other individuals on his behalf contact victims and witnesses. And yet, under those circumstances, the court found that even for the pendency of the coronavirus pandemic, that release was not appropriate in this case.
Thank you, Ms. Melendez.
Your Honor, thank you. The government asked that the court affirm the district court's order denying bail. Thank you for your time.
With your rebuttal.
Thank you, Your Honor. So let's first deal with the issue that this trial will take place. This Kelly's trial we've already rescheduled jury selection twice. The Northern District of Illinois case has multiple defendants who have been released on bond, and so it's likely that trial is a little bit further out for motion practice and other reasons. So it's likely that the Eastern District case would be tried first. Additionally, there has been a bail application in the Northern District of Illinois that has been made in light of this court hearing this application. Now, with regard to trial management issues, United States versus Stevens, which was decided during this time, has said unequivocally that the defendant meets the burden by demonstrating at least one compelling reason that necessitates his release under 3142I, and namely the obstacle the current public health crisis poses to the preparation of the defendant's defense constitutes a compelling reason under 3142 for release. And that was the case in which the defendant had originally been detained. With regard to meetings in person, defense counsel should not have to be faced with the prospect that they may contract the potential virus, especially given the circumstances that in the Eastern District, in the MTC and the MDC, the guards were tested to have had coronavirus in greater numbers than the inmates. We would certainly be at risk in doing so. And then additionally, the Councilor, yes.
Please, Judge Walker. The trial has been put off. There's a lot of uncertainty. Let's assume there's a trial date picked in the Eastern District. It's not going to be until after November. So between now and then, he would be transferred to the Northern District of Illinois to the Eastern District of New York. And then there would be several months, presumably, before the trial. Now, why under those circumstances can he then make an application, or you on his behalf, to the district judge saying, we're not able to prepare the thousands of documents here. We can't. It's dangerous in the NBC. And why don't we? Can you make a room available, and we can meet for 3 days and pick the days to take the documents there and go over them all with him and so forth with marshals present. Arranging by the trial judge can arrange that his Sixth Amendment rights are protected in advance of the trial, and handle it that way. That seems to be a logical way to do it, rather than just granting him bail, which would be extraordinary for a person of this sort, absent COVID. Why not just be able to manage it that way? And the district judge is going to accommodate it because he doesn't want a motion that Sixth Amendment motion argument made on appeal that he's denied the person the opportunity to prepare.
Well, Your Honor, thank you for the question. The reality is that for almost more than half the time that he's been incarcerated, he's not been able to meet with counsel. The amount of work that has to be done, especially given the exceptional circumstance and the uniqueness in Mr. Kelly's case, in which he cannot read. There's an extraordinary amount of work that has to go into being prepared. And as was stated in U.S. data, where the defendant released on bail is available 24 hours a day to assist in trial preparation. This is the type of thing that is necessary for the amount of, for what Mr. Kelly is facing. There are other defendants who have already been convicted in the Southern District of New York who were granted bail, and they are being housed in very limited restrictions where they have where the government is able to monitor, as well as the Bureau of Prisons are able to monitor the defendant. And it's not a circumstance that's unusual while the pandemic is ongoing. And the courts have ruled that release has no bearing on any other bail applications that may have resulted in detention. The fact remains that Mr. Kelly needs to prepare for trial in person, face to face with his lawyers, and to lock him away for 6 months without any contact to counsel. It belies his right to counsel and his constitutional guaranteed right. There's no way that
what if the trial date were set for next June? Would you still be making the same arguments? I mean, we don't know when this trial is going to take place. And it seems to me that if he has several months before the trial takes place when he's in the Eastern District of New York, that's the time to address all of this. He's sitting in Illinois, and who knows when he's going to come east, but there isn't even a trial date. So, it seems like there's an awful lot of moving parts here that need to be settled before a decision of the magnitude that you're asking for could be possibly made.
Well, again, United States versus Avenatti, Mr. Avenatti was found guilty of multiple felonies, and the court allowed his temporary release for 90 days to prepare for trial, and the court continues to extend the release dates for Mr. Avenatti, and the fact that he is facing a trial in California and he had another trial in the Southern District of New York, and he is free to consult with his attorney, and the court determined this because he has a right to prepare for trial. Mr. Kelly can be placed under extraordinary restrictions in Chicago, where we can at least go there and prepare with him if necessary, or in the vice versa. There can be a condition set up where Mr. Kelly is restricted from any outside access as if he were in the Bureau of Prisons. And that really, truly, would be one less prisoner that the prisons that they're worried about contracting this virus. I mean, it's in the public interest to ensure that Mr. Kelly gets a fair trial, and it's not deemed that he's locked away in the MCC. Again, he was just recently tapped because of who he is. And so the fact remains that the same result can happen. It just doesn't have to happen within the Bureau of Prisons, given the compelling circumstances of this pandemic.
Thank you, Mr. Farinella. Thank you, Mr. Farinella. I have one other question. The government did proffer evidence of recent obstructive conduct in the prison. If you could just address just that point, the smuggling mail and engaging in unmonitored calls, and a letter in which a victim was threatened.
Did that question to me, Your Honor, or?
Yes.
Did you ask that question
to you? Did you just? No, I did not to the government, just to you. It was in their papers. And this is in response to your point that he can be monitored if released on bail in order to prepare for trial. But the government's response to that is that there's recent evidence of obstructive behavior, smuggling mail and like while he's in the detention facility. And why doesn't that suggest that it may be difficult to monitor him in the way that you suggest in order that he could prepare for trial?
Thank you for the question, Your Honor. The reality is the government's proffer provides no information to bolster their support that Mr. Kelly needs to have. This is a supplemental filing in their motion for anonymous and sequestered jury. There is no evidence connecting Mr. Kelly to these three individual actors and what they did. There's no evidence that corroborates the government's assertion. They're blanket assertions in an effort to try to tip the balance to ensure that Mr. Kelly stays exactly where he is. If in fact Mr. Kelly was actively involved with these three actors, then then it would be clear that Mr. Kelly would be facing additional charges. There is no evidence to support the allegations in the government's proffer to their supplemental filing, Your Honor.
Thank you, Mr. Farinello. We'll take the matter under advisement. Thank you both. Well argued. That is the last
Thank you, Your Honor.
on the. Thank you.
If you took the second to research this history of abuse that these agitators like to talk about, you would begin to realize some interesting facts. Like, for example, to start it off, you can tell that this is a clear case of extortion. And if you look at the beginning, which would be Aaliyah, and look at the circumstances surrounding this alleged marriage, you will begin to question the very existence of this alleged marriage. If this alleged marriage took place, why was it necessary to produce false documents? And even more so, why is it acceptable to have the person who claims responsibility in allegedly bribing the people to get this action done? Why isn't this person being charged? Why is this person being given the platform to tell you about this illegal action? Anybody with eyes can see the clear deception and see the difference between this alleged certificate of marriage and a real marriage certificate. With that being said, from the beginning, this alleged marriage has been used as the clutch to always go with the narrative that R. Kelly likes underage, despite the fact that just as quick as you can say, why is this little girl singing about age ain't nothing but a number? Why was she at 16 singing about if your girl only knew? And go down her whole playlist then. Go down any teenage pop star at that time's playlist and just think about the things that they were insinuating and the things they sung about. Yet, does that confirm that something funny was going on between that artist and whoever they were working with? What are the odds that the person sitting here telling y'all about this story of getting an underage girl married illegally is also manager to another alleged victim who comes out and who was more than likely possibly in a relationship with him, considering she's come out talking about this baby that wasn't R. Kelly's? You would be absolutely delusional to think that these people do not know each other and could not have come together to conspire this grand plot against this person. What are the odds that the man managing this person is also the uncle to an alleged victim and continues working with this man 5 years after the fact, meanwhile possibly doing a lot of shady business in the background? What are the odds that a friend of a friend couldn't get mad because their career didn't go as they expected? So they, just like others, went along with this plan to get money out of this celebrity. Considering the fact that this said person was a key witness in this case against R. Kelly in 2002 and was very all over the place with her testimony, it's safe to say that she's not going to be a credible witness in this case.
Stop it. Y'all quit playing. Quit playing. I didn't do this stuff. This is not me. I'm fighting for my life. Y'all killing me with this. I gave y'all 30 years of my career.
Robert.
30 years of my career. Y'all trying to kill me. You killing me, man. This is not about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment. His publicist helped calm him down.
I hope this camera keep going.
No, we're gonna
This
let
is
the
not
camera keep
true.
rolling. Okay,
This is not, doesn't even make sense. Why would I hold all these women? Their mothers and fathers told me, we're going to destroy your career.
But Kelly's emotions remained raw.
It's real girls out there missing. It's real young girls out there being abducted, being raped, okay? They really are on chains. They really do have chains on their wrists, and they can't get out.
Robert,
and they're ending up buried in deep.
Robert, we have to have a conversation.
This is
Really,
not me.
I don't want you just ranting at the camera.
I came here for them to hear me talk.
But
I need help.
What kind of help?
This is the kind of help I need.
Yes, what kind of help?
I need somebody to help me not have a big heart, because my heart is so big. People betray me, and I keep forgiving them.
You sound like you're playing the victim here. You sound like R. Kelly, you do. When I listen to you,
I'm
it
just
does
telling
sound
the
like
truth.
you're playing the victim
I'm just
card.
telling the truth. And the reason I'm emotional,
But Robert,
and I apologize for that,
No,
is
no,
because
no,
this
no.
is the first time I was able to say
speak.
something. I've said nothing.
Especially when you consider how many times the song and banana have been referenced in pop culture. I'd say there are a few out there that could top it in terms of recognizability. Oh, and speaking of pop culture references, I can't believe I'm just now realizing this, but holy shit, the mandatory dance from World of Warcraft is the peanut butter jelly time dance. I'm just now figuring this out. In conclusion, while what happened to the vocalist was indeed tragic, I think a lesser talked about
It's clear it was a rush to judgment in this case.